kids, how are you? I hope that you will be fine and happy. Today we will read this chapter 4, the Judiciary. Okay, so let's start now this chapter, kids. The Bharatiya Judiciary is independent of the legislative and executive control. जो भारतीय न्याय प्रणाली है वो हमारी किस पर, लेजिस्लेटिव पर और एक्सिक्यूटिव काउंसिलिंग पर डिपेंडेबल है. इट इंटरप्रेट्स एंड द सेफगार्ड्स द कॉन्स्टिट्यूशन. जब संविधान द्वारा इसकी सुरक्षा के नियम बनाए गए हैं, इट इज द ओरिजिन ऑफ गवर्नमेंट दैट मेक्स श्योर एवरीथिंग हैपन्स अकॉर्डिंग टू द लॉ. तो लॉ के अनुसार जितने भी हमारे कार्य थे जो सरकार द्वारा संचालित थे, है ना, उन सभी को संविधान के अनुसार बहुत सेफ्टी गार्ड के रूप में या फिर उसको एक सही मार्गदर्शन के रूप में रखा गया. इट अप्लाइज द लॉ टू पनिश द गिल्टी एंड सेटल डिस्प्यूट्स. यहाँ तक कि कानून का दायरा होता था कि वह झगड़ों को निपटारा करे और जो गलत कार्य है उसका सही न्याय दंड करे. इट प्रोटेक्ट द राइट्स ऑफ द सिटीजन. ये हमें प्रोटेक्ट करता है नागरिकों के अधिकार के लिए, इंक्लूडिंग द फंडामेंटल राइट्स, और हमारे मौलिक अधिकार के लिए. इट जुडिशरी वर्क्स थ्रू अ नेटवर्क ऑफ द कोर्ट. यहाँ तक कि जो भी जुडिशरी न्याय में जो भी कार्य किए जाते हैं वो एक अदालत के नेटवर्क के जरिए होते हैं. जैसे यहाँ पर हम देखते हैं, ये क्या है, सुप्रीम कोर्ट. सुप्रीम कोर्ट के बाद आता है हाई कोर्ट. ओके, सुप्रीम कोर्ट के दो कार्य, अपील्स लगाना, है ना, और उन अपील्स की भी तीन जगह अपील्स लगाना, और हाई कोर्ट की भी, और इधर जो सुप्रीम कोर्ट के कार्य होते हैं वो इन सब चीजों में, इन सब में बटते चले जाते हैं. ओके, चलिए, तो ये भी क्या है, नेटवर्क है. A person can be punished for an offense only if the provide guilty in the court of law. यदि कोई व्यक्ति गलत कार्य करता है तो उसे अदालत के आधार पर क्या किया जाता है, पनिश किया जाता है. The law courts are presided over by the judge. और जहाँ तक कि और जज के द्वारा जो भी निर्णय लिया जाता है वो सभी को मान्य होता है. The deal with cases against individual organizations and the government. Okay, चलिए आगे. टाइप्स ऑफ केसेस. The cases brought before a court of law are mainly of two types. Number first is civil, number second है criminal. Civil cases involve disputes related to money, property and social matters like inheritance, divorce. Criminal cases involve offense such as theft, robberies, murders, cheating, etc., which causes harm to members of the society. चलिए, सिविल एंड द क्रिमिनल केसेस हैं. There are two kinds of cases that are heard in the trial courts. Number first है civil cases, number second है criminal cases. Civil cases involve conflicts between people or institutions such as businessmen. A civil cases usually begins with the persons or organizations determines that a problem can't be solved without going to court. Divorce and the related lawsuits जैसे child supports, custody, etc., personal injury, breaking of the contract, etc., are some common kinds of civil cases. In personal injury cases में a person is injured and bring a lawsuit against the person at fault seeking money damages. A common types of the personal injury cases comes from automobile collisions. An auto collision gives rise to a civil cases if one driver sues the other if a passenger in one of the cars shoots either driver. An automobile collision gives rise to civil cases which involves allegations of a crime such as the drunken driver or the leaving the scene of an accident. यहाँ तक कि जब कोई कार ड्राइवर या तो ड्रंकन होता है, पीने वाला ड्राइवर होता है, जब कोई भी ऐसी स्थिति में कोई भी एक्सीडेंट हो जाते हैं तो उसी कानून के आधार पर जो भी दंड दिया जाता है उसको माना जाता है. A person who sues in a civil cases generally wants the court to order the person at fault to pay them money damages. Okay, चलिए आगे हैं क्रिमिनल केसेस में. क्रिमिनल केसेस इन्वॉल्व एनफोर्सिंग लॉ. क्रिमिनल केसेस में जितने भी कार्य होते हैं, जितने भी दबाव होते हैं, सब कानून पर आधारित होते हैं. इन क्रिमिनल केसेस द गवर्नमेंट ब्रिंग्स चार्ज अगेंस्ट द पर्सन accused of the committing a crime. यहाँ तक कि कोई भी यदि सोसाइटी में क्राइम होता है, सच एज जैसे रोबरी, मर्डर ऑफ द ड्रंक ड्राइवर का, एन एग्जाम्पल ऑफ अ क्रिमिनल केस वुड बी इफ एनी सिटीजन इज अरेस्टेड ऑन सस्पिशन। यहाँ तक कि भारत कानून कहता है कि यदि हमें किसी भी व्यक्ति पर संदेह है और कोई कानूनी घटना घटती है तो हम उस व्यक्ति को पकड़ सकते हैं, मीन अरेस्ट कर सकते हैं। द स्टेट वुड ब्रिंग्स क्रिमिनल चेंजेस अगेंस्ट द सिटीजन फॉर मर्डर। यहाँ तक कि कोई नागरिक द्वारा यदि कोई मर्डर किया गया है तो उसको तो सरकार द्वारा बाद ही अर्थात कस्टडी में लिया ही जाएगा, बल्कि जो सस्पिशियस है, जो संदेह में, उसको भी पकड़ा जाएगा। The citizen would then go to court to stand trial on the charges. Okay, नंबर फर्स्ट है क्रिमिनल लॉ, नंबर सेकंड है सिविल लॉ। चलिए करते हैं। क्रिमिनल लॉ deals with conduct or acts that the law defines as the offenses. For example, theft, harassing a woman to bring more dowry, murder. Next है deals with any harm of the injury to rights of the individual. For example, disputes relating to sale of the land, purchase of the goods, rent, matter, divorce cases. चलिए क्रिमिनल लॉ में आते हैं। इट यूजेस बिगिन विद द लॉडिंग ऑफ एन फर्स्ट इंफॉर्मेशन रिपोर्ट, एफआईआर, जिसे कहते हैं हम पुलिस को इन्वेस्टिगेट कर रहे हैं। पुलिस क्या करते हैं, क्राइम को इन्वेस्टिगेट करते हैं, आफ्टर विच केसेस फिल्ड इन द कोर्ट, और उसके बाद कोर्ट में जाकर दे देती है। फिर a petition has to be filled before the land court by the affected party only. It is rent matter, either the landlord or the tenant can file a case. चलिए आगे, if found guilty, the accused can be sent to jail and also fined. चलिए, the court gives the specific relief asked for. For instance, in a case between a landlord and a tenant, the court can order the flat to be vacated and the pending rent to be paid. Okay, चलिए, structure of the judiciary का है। The भारतीय judiciary has a pyramidal structure. जो भारतीय न्याय का जो एक स्ट्रक्चर है वो कैसा है, pyramidal structure है। The Supreme Court, which is the highest court in the country, it at the top of the pyramid. pyramid में जो सबसे टॉप पर है वो सुप्रीम कोर्ट है। The Supreme Court was inaugurated on 28 January 1950 में at the court houses in the New Delhi. न्यू दिल्ली में इसका क्या है, सुप्रीम कोर्ट है। Below the Supreme Court are the High Court. सुप्रीम कोर्ट के नीचे हाई कोर्ट होता है। The High Court is highest court at the state level. जो हाई कोर्ट होता है वो स्टेट लेवल पर कार्य करता है। Some of the state and the union territories share a common high court. यहाँ तक कि जितने भी सामाजिक और राजनीतिक और राज्य के स्टेट लेवल के जितने मुद्दे होते हैं सब हाई कोर्ट तक आते हैं। Below the high court there are the subordinate courts. हाई कोर्ट के नीचे भी बहुत सारे कोर्ट लगते हैं। The judiciary is single and united. The main cases from the lower courts can be taken in the appeal of the high courts. यहाँ तक कि सबकी सुनवाई हाई कोर्ट में होती है, लेकिन कार्य नीचे वाली अदालत भी करती रहती है। And ultimately to the Supreme Court, the Bharatiya judiciary is independent. This means that the other organs of government, namely the legislative and the executive, cannot therefore in its decision. Okay, चलिए, यहाँ पर है सुप्रीम कोर्ट। The Supreme Court is the highest judicial authority in the country. The Supreme Court of the Bharat is located in New Delhi. Next है composition of the Supreme Court. The Supreme Court has a Chief Justice and a number of the other judges. However, the total number of the judges should not be more than 26, including the Chief Justice. Next, appointment of the judges. The judges of the Supreme Court are appointed by the President on the advice of the Chief Justice of Bharat and the Court of Ministers. The Chief Justice is appointed by the President of Bharat on the advice of the other judges of the Supreme Court and the Council of Ministers. चलिए, qualification to be judges of the Supreme Court के हैं। He she must be the भारतीय citizen. सबसे पहले तो वो भारत का नागरिक होना चाहिए। उसके बाद है he she must have been an advocate of the High Court or the two or the more courts in session for at least 10 years. लगभग उसने किसी भी कोर्ट से 10 years का एक्सपीरियंस लिया हो. She should have been a judge of the High Court for 5 years continuously. लगातार 5 सालों के लिए वह हाई कोर्ट में जज रहा हो. She should be distinguished jurist in the president's opinion. यहाँ तक कि वो से भी प्रेसिडेंट की ओपिनियन भी जजेस मतलब उसको सही निर्णय में लेता हो. Tenure of the judges, a judge of the Supreme Court continues to hold office till 65 years of age. He can't be removed before the end of his term except on ground of the proven misbehavior or capacity by the process of the impeachment. Okay. चलिए next is salary and the allowance. The Chief Justice of Bharat receive a salary of 1 lakh while the other judges get 90,000 monthly apart from salary. है ना? They are also entitled to free accommodations, transport and the other facilities. Powers of the Supreme Court की. The Supreme Court has 3 kinds of the powers to pass judgment in the civil and criminal cases. Original jurisdictions, appellate jurisdictions and the advisory jurisdictions. Okay, इन सभी चीजों इनमें पावर्स में इनको डिवाइड कर दिया जाता है जिसके जो कार्य होते हैं वही संस्था उस कार्य को करती है. ओके, चलिए आगे. ओरिजिनल jurisdictions है the cases that are brought directly before the Supreme Court come under original jurisdictions. This may take place under the following circumstances. Number first है in cases of the dispute between the union government and the state government or more than one state government. Next है in cases of the dispute between one state government and another, in cases when the individual or the government violates and the constitutions. चलिए next है in the cases of the fundamental rights of an individual are violated. Next है appellate jurisdictions. Under appellate jurisdictions, the Supreme Court hears the appeals against the decision made by the high courts. The Supreme Court is the final court of appeal and has the power of review or alter the decision made by the high courts. चलिए आगे advisory jurisdictions. The president may request the Supreme Court to advise him or her on legal and the constitutional matters. However, the president may or may not accept the advice. Next, a court of record. The Supreme Court is regarded as court of the records as it records all the proceeding of the cases handled by the court. The judgment passes are also recorded for future reference. Next is guardians of the fundamental rights. चलिए, the Supreme Court is looked up to as the guardians of our fundamental rights. Next is High Court. The High Court is the highest judiciary authority in the state. State level पर जो सबसे ज़्यादा highest authority होती है वो हाई कोर्ट की होती है. In certain cases, the high courts have 2 or the more state and the union territories falling under their jurisdictions. Okay, चलिए. Next है composition of a high court. The highest level of the authority of the high court is the chief justice. Next है it comprises of the judges depending on the size of the state concerned. The number of the judges is decided by the president. Next है appointment of judges. The president appoints the chief justice of a state high court on the advice of the chief justice of Bharat and the governor of the concerned state. Next is the president appoints the other judges on the advice of the chief justice of the Bharat and the governor of the concerned state. Okay, चलिए next है qualification required to be the judge of the high court का. नंबर फर्स्ट है भारतीय सिटीजनशिप होना जरूरी है. Must have had experience in the judicial office for at least 10 years. लगभग कम से कम 10 सालों का एक्सपीरियंस होना चाहिए. must have been an advocate of the High Court or the two or the more such courts for at least 10 years. यहाँ तक कि किसी भी हाई कोर्ट में या फिर कोई भी कोर्ट दो या एक या दो कोर्ट में कम से कम 10 साल का एक्सपीरियंस होना चाहिए. फिर है tenure of the judge of the high court hold their post till age of the 62. यहाँ तक कि हाई कोर्ट की जो जज वो होती रिमूव की एज होती 62 till they retire. जब वो रिटायर होंगी तब उनकी उम्र 62 होनी चाहिए. However, they may be removed by the president or by the impeachment. They may resign earlier if they wish to do so. यदि तुम जल्दी रिजाइन देना चाहते हो तो वो तुम्हारी इच्छा है. Next है pay and allowance. The Chief Justice of a High Court is entitled to get a salary of 19,000 and other judges 80,000 monthly. जो चीफ जस्टिस होते हैं, जो चीफ मुखिया होते हैं हाई कोर्ट के, वो क्या होते हैं, उनकी सैलरी 90,000 होती है और अदर जजेस की 80,000 मंथली होती है. They are entitled to the rent-free furnished home with general facility. और यहाँ तक कि उन्हें रेंट फ्री घर रहने के लिए दिया जाता है. The judge of the High Court also get other allowance as approved by Parliament from time to time. चलिए आगे powers of the High Court. The High Court, like the Supreme Court, has the following powers. Original judications है, in which the cases are brought to the High Courts directly. These cases can involve dispute concerning fundamental rights, election, position, and so on. Next time, appellate judications, in which the High Court listen to the appeals made against the judgment passes in the subordinate courts like the district courts, like the Supreme Court, and the High Court is also empowered to review and alter the decision made by the lower courts. Chale, it also controls and supervises the working of the subordinate courts. आगे है courts of records, like the Supreme Court. The High Court also records the proceeding of the cases and the judgment passed for future reference. Next है public interest litigations, जिसे कहते हैं PIL. Public interest litigation means litigations for the protection of the public interest. जो PIL होता है वो लोगों के इंटरेस्ट को क्या करता है, प्रोटेक्ट करता है. It is litigation introduced in a court of the law. और कानून के अनुसार जो भी कानून या कोई भी टैक्स होता है उसे भरता है, not by the aggrieved party but the court itself or by any other private party. It is not necessary for the exercise of the court jurisdiction that the person who is the victim of the violations of his or her right should personally approach the court. Public interest litigations is the power given to the public by court through judicial activism. Such cases may occur when the victim does not have the necessary resource to commence litigation or his freedom to move court has been suppressed or the endorsed upon. Chaliye. The Supreme Court has now released its proper role in welfare state and it's using the new strategy for the development of a whole new corpus of law for effective and the purposeful implications of public interest litigations. One can simply approach the court for the enforcement of the fundamental rights by the writing a letter or the postcard of any judge. That particular letter, based on the true facts and the concept, will be converted to right petition. When the court welcomes public interest litigations, its attempt to endure observance of the social and economic programs framed for the benefit have not and the handicapped. Okay, public interest litigation has proved a boon for the common man. It has set right a number of the wrong committed by an individual or by the society. By relaxing the scope of the public interest litigation, the court has brought legal aid to the doorstep of the teeming millions of the Bharatiya, which executive has not been able to do despite a lot of money being spent on new legal and schemes operating at the center and the state level. चलिए आगे subordinate courts. They are the several subordinate courts placed under the supervision of the High Court. Next है district court. A state is divided into state को divide किया जाता है district पर for administrative conveyance किया जाता है. At the district level, the High Court dealings with civil cases is the court of the district judge. जो civil level के cases होते हैं उसे district judge handle करता है. The court of the session judge is the highest district court for the criminal cases. The district judge also acts as the sessional judges. The courts at the district level here appeals against the decision of the lower courts. Appeals against the decision of the district court are taken to the High Court of the state. चले रेवेन्यू कोर्ट्स हैं और डिस्प्यूट जितने भी सारे झगड़े होते हैं कंसर्निंग द पेमेंट ऑफ द रेवेन्यू आर सेटल्ड थ्रू रेवेन्यू कोर्ट्स. The board of the revenue is the highest revenue court in a state and appeals can be taken from the board of revenue to the High Court. The court of the collector is the most important revenue court in a district. Below this, there are the lower courts. ये कितने होते हैं? Lower courts होते हैं. न्याय पंचायत और the panchayat courts. In the rural area, there are the small low courts known as the न्याय पंचायत. A न्याय पंचायत often serves 3 or the 4 villages. यह किसमें सेवा देते हैं? 3 और 4 villages में. It tries petty civil and the criminal cases and can imposes small fines. Matters related to the theft, trespassing, and so on, and tried here. Appeals can be taken from the Nyaya Panchayat to higher courts. Okay? चलिए, लोक अदालत. It is said that justice delayed to justice denied. In our country, the legal process has become lengthy and expensive. To solve this problem, Lok Adalat have been introduced. Lok Adalat simplifies the legal procedure. They provide quick and cheap judicial services. They are the presides over by retired judges. The disputing parties put forward their case and the matter is settled without a pleader or an advocate. The first Lok Adalat was held in Delhi in 1985 and nearly 150 cases were settled in a day. Okay. Next is legal aid. According to the Bharatiya Constitution, all citizens are equal before the law, irrespective of the caste, creed, social status, gender, or the religion. Under the legal aid scheme, free legal aids and the legal services are made available to the poorer and weaker section of the society. Some of the categories for which free legal services are provided by the government are: number first है people belonging to the scheduled caste, scheduled tribes in the backward classes. Next है people who are the mentally ill or disabled. Women and the children, victim of the trafficking in the human beings, are beggars. Persons whose annual income is less than 25,000 or such other higher amount as may be prescribed by the state government. If the case is put before any court other than the Supreme Court. Next है persons with the annual income जिसकी less than 50,000 से or such other higher amount as may be prescribed by the central government. If the case is presented before the Supreme Court. When a crime is committed, the police can arrest the suspected person, but can't be directly punish him. First, his guilty must be proved in a court of the law. The court passes judgment according to the laws of the land and the constitutions, which are which are appropriate for the crime committed in these cases of the dispute between two or the more persons or organizations. The court decide which party is in the right. Judgment are thus supposed to make emphatically without base or the prejudice. Okay, this is the key with the concept of the equality before the law in the Bharatiya Constitution. Next step, first information report. The first information report is called FIR. Is a written document prepared by the police. Well, it receives information about the commission of the alleged offense. It is report of information that reaches the police first in the point of time, and that is why it is called the first information report. जो पहले आकर पुलिस को रिपोर्ट देते हैं उसी को कहते हैं फर्स्ट इंफॉर्मेशन रिपोर्ट, मीन FIR. It is a generally complaint lodged with the plus by the victim या by someone or his or her behalf. यहाँ तक कि कोई व्यक्ति घायल हुआ है या उसकी बिहाफ पर या तो कोई और दे या फिर वही घायल व्यक्ति दे, जो पहले सूचना पुलिस को देता है उसे FIR कहते हैं, जो रिटन रिकॉर्ड में लिखा जाता है. Anyone can report any offense either orally or written to the police. A telephonic message can also be treated as the basis for an FIR. Next, importance. An FIR is very important document as it sets the process of the criminal justice in motion. It is only after the FIR is registered in the police station that the police takes up investigation of the case. Anyone who knows about the commission of a cognizable offense can file an FIR. It is not necessary that only the victim of the crime should file on FIR. और सबसे पहले जो भी घायल द्वारा लिखाया जाता है पुलिस को उसे कहते हैं FIR. A police officer who comes to know about a cognizable offense can file an FIR himself or herself. एक ऑफिसर अच्छे से जानता है कि FIR को किस तरह और कहाँ लिखनी चाहिए. चलिए, where to file an FIR, कहाँ होती है फाइल FIR की. FIR can be filled in the police station. FIR की जो फाइल होती है वो पुलिस स्टेशन में फिल की जाती है. Of concerned area in the whose jurisdiction the offencer has occurred. It must be made to the offer in charge. यहाँ तक कि उसके ऊपर कुछ चार्ज भी लगाया जाता है. Of a police station, and if he is not available, यदि वह उपलब्ध नहीं है तो assistant sub inspector is completed to enter upon the investigation. तो सब इंस्पेक्टर उसका आगे करता है. आगे how to file an FIR. फाइल कैसे करते हैं FIR पर? When something wrong has been committed, यदि कोई गलत कार्य हो रहा है and the aggressive person on any other person wants to file an FIR, और कोई व्यक्ति FIR करना चाहता है, it shall be filled in the following manners. उसकी कुछ manners होते हैं. नंबर फर्स्ट, go to police station. सबसे पहले तो पुलिस स्टेशन में जाएगा and meet the officer in charge, और ऑफिसर को चार्ज करेगा. Step by step in the ordinary sequence, narrate to the officer every information. उसे सारी information बताएगा related to the commission of the offense को. फिर the officer shall reduce the information given in written. जो ऑफिसर होगा वह उसकी बातों को रिटर्न में पेश करेगा. The information given shall be singled by the person giving it. यहाँ तक कि जो दोनों केसों में लड़ाई होती है उसमें से एक केस द्वारा सबसे पहले जो भी जाकर लिख देगा उसे FIR कहते हैं. The information given shall be entered in a book to be kept by the officer. और उस बुक को फिर एक ऑफिसर उसमें रख देते हैं. Copy of the information as recorded shall be given free to cost to the informant. Okay, चलिए next step. Here the officer in charge refuse to record the information. In the officer in charge refuse to record the information may be sent in return. जो information होती है वो sent return में भेजी जाती है by post द्वारा to the superintendent of the police concerned who is satisfied that such information discloses the commission of a cognizable offence shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him. चलिए कंज्यूमर काउंसिल्स हैं. Recently, consumer councils have been set up to decide the complaints of the consumer. Recently, वास्तव में जो कंज्यूमर काउंसिलर्स होते हैं वो क्या करते हैं, कंज्यूमर्स के अकॉर्डिंग उनकी निर्णयों को डिसाइड करती हैं. जस्टिस इन सच कंज्यूमर काउंसिल्स इज वेरी सिंपल. नो कोर्ट फी इज चार्ज. These are becoming very popular because consumer cases are decided speedily in about 3 to 4 month times. Such consumer councils are organized at the district level, state level and the national level. These courts entertain cases when a consumer alleges that the producer or the seller of a product has done a fraud and the supplied defective quality product. Okay, the consumer council grant compensations with interest to the consumer who knock at its door. चलिए नेक्स्ट है इंडिपेंडेंस एंड impartiality of the judiciary. Meaning by independence of the judiciary, न्याय के अनुसार जब हम स्वतंत्र होते हैं, we mean its independence from the control of the executive and the legislators. This also mean a fair, impartial, fearless and the honesty judiciary. It should be above favor of the firm in the giving its judgment and in doing its duty as the guardians of the constitutions and the rights of the people. जैसे हमारी गार्जियंस हमें सही दिशा दिखाते हैं, ऐसी कॉन्स्टिट्यूशन भी लोगों को एक सही दिशा निर्धारित करता है, अधिकार समझाता है. ओके, चलिए रीजंस हैं. इट इज एसेंशियल फॉर द फंक्शनिंग ऑफ अ डेमोक्रेटिक constitutions like to be natural and impartial in the dispensations of the justice. Even it is judgment so against the government of Bharat to order punishment of the official of the government for failure to implement its judgment or disorders, and annual laws made by legislator on the grounds of their being ultra vires exceeding the power granted by law of the constitutions to safeguard the dignity of the judges of the court. यहाँ तक कि जो भी safeguard में जो भी dignity होती है वो अदालत में जजेस द्वारा दी जाती है. Next है importance of the judiciary का. The judiciary plays very important role in Bharat. Next, it protects the fundamental right. ये protect करता है fundamental rights को of the citizens के and preserve करता है democracy को. Next is the भारतीय judiciary is single and united. Appeals against the decision of lower courts can be taken to higher courts. Next is the Supreme Court interprets the constitutions and prevents the violation of the constitutions. Okay. Actually, the judiciary is kept free from the interference of the other organs of government so that it can give us impartial justice. Okay. Now, kids, this chapter will be completed. I hope that you understood well. Thank you. Have a nice day.